Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through the Vermont Data Privacy and Online Surveillance Act and its main privacy requirements. Vermont's data privacy law establishes consumer privacy protections for Vermont residents and creates compliance duties for certain data controllers and processors effective January 1, 2028. The law, known as Bill S-71, successfully passed both chambers of the Vermont General Assembly during the 2026 legislative session and was officially signed into law by the governor on June 16th that same year. The entire act goes into effect on January 1st, 2028, which also kicks off an initial statutory cure window for businesses. The law targets companies operating in Vermont or serving its residents. A business falls within scope if it processes the personal data of 35,000 or more consumers, handles sensitive data for 3,000 or more consumers, or sells the personal data of at least 3,000 consumers. Statutory exemptions apply to government bodies, entities covered by the Health Insurance Portability and Accountability Act, and healthcare providers, Gramm-Leach-Bliley Act, financial institutions, and specific categories of data such as employment records, credit reporting info, and purely personal or household data. In-scope businesses face strict operational duties. Data controllers must minimize collection to stated purposes, implement robust security, respect consent revocations within 15 days, ban targeted ads and data sales for teens under 18, and use structured vendor contracts. Website owners must place a conspicuous privacy link on their homepages, offer frictionless request methods without forcing account creation, and honor global opt-out signals. Crucially, your privacy notice must explicitly state if user data is utilized to train large language models. Businesses must answer rights requests within 45 days and resolve appeals within 60 days. Data protection assessments are legally required for high-risk processing, targeted advertising, or consumer profiling, applying to new operations starting January 1st, 2028. Vermont consumers gain comprehensive rights to access their data and derived inferences, correct inaccuracies, delete personal data, and receive a portable copy. They can also opt out of data sales, targeted ads, and automated profiling, with an added right to question profiling results. The Vermont Attorney General holds exclusive enforcement power, treating violations as deceptive trade practices with civil penalties reaching up to $10,000 per individual violation, alongside court-ordered injunctions, consumer restitution, and investigative cost recoveries. A mandatory 60-day cure period is available from January 1st, 2028 through June 30th, 2029. Regular consumers do not have a private right of action under this act. Thank you for joining us. At Clym, we're here to help you navigate compliance with ease. Visit us at clym.io to learn more about our all-in-one digital compliance solution.